The 1951 Refugee Convention is the central instrument in international law that pertains to the status and treatment of refugees. It's an international treaty, which means that it's an agreement that different countries have agreed voluntarily to be bound by. And Australia is one of those countries. The 1951 Convention was really a response to the displacement that had happened during the Second World War. So that instrument defined refugees as people who are outside their country with a well-founded fear of persecution for one of 5 reasons, namely nationality, political opinion, religion, membership of a particular social group, or their race. Originally, that treaty said that you were only a refugee if you were fleeing events that had occurred prior to the 1st of January 1951. However, in 1967, countries adopted a protocol to the 1951 Refugee Convention, which essentially removed that limitation. By ratifying the Refugee Convention, Australia promises to abide by the obligations set out there. Perhaps the most important one is the principle of non-refoulement or non-return, which is contained in Article 33. This means that Australia has promised not to send refugees back to places where they fear persecution for reasons of their race, religion, nationality, political opinion, or their membership of a particular social group. The Refugee Convention, as I mentioned, is a treaty. But treaties don't have direct application in Australia unless they have been essentially turned into part of our domestic law. So some of the important obligations that Australia has are translated into our Migration Act. And Australia, through the Migration Act, undertakes to protect refugees in accordance with the 51 Convention. Another important element of the Refugee Convention is contained in Article 31, and that's the provision that says that countries will not penalise asylum seekers when they are arriving in a country without documents in search of protection. The reason for that, of course, is because the very nature of refugee flight might mean that you simply don't have documentation with you when you need to flee, but it also can be because a person, for instance, who is fighting against a particular regime won't be able to obtain a passport from that regime. And the other point, of course, as well, is that countries don't issue refugee visas outside their own territory. So essentially, to be a refugee, you need to cross an international border. And if you then find your way to an Australian consulate, if there is one in the place that you are, you can't say, I need your protection, Australia, right here, and be issued with a visa. And it's very unlikely you'll qualify for a tourist visa or a work visa or similar kind of visa, precisely because of the assumption that you're not really a tourist, that instead, when you arrive in Australia, you'll seek asylum. In addition to the principle of non-refoulement or non-return under the Refugee Convention, human rights law also contains protections against return. Importantly, under the ICCPR, the International Covenant on Civil and Political Rights, and also the Convention Against Torture, countries are prevented from returning people to a place where they face a real risk of being tortured. Further, under the ICCPR, countries are precluded from sending somebody back to a place where they would be at risk of being killed or otherwise arbitrarily deprived of their life. Countries also can't return someone if they are going to be at risk of the death penalty or if they might be exposed to cruel, inhuman or degrading treatment of punishment. This is generally known as complementary protection because it complements the non-refoulement obligation in the Refugee Convention. Of course, refugee law is part of broader international human rights law. And that's important because although the Refugee Convention stipulates particular rights that are owed to refugees, all refugees are of course human beings and therefore have entitlements under the general human rights treaties as well. There are also a couple of regional refugee instruments. The first of these is the 1969 OAU Convention, which applies in Africa. In addition to picking up the refugee definition from the 1951 Convention, this treaty also says that refugees are people who are fleeing such things as occupation by another country, foreign aggression, events seriously disturbing the public order, and so on. There's also a Latin American instrument known as the Cartagena Declaration from 1984. Similarly, this applies to people fleeing foreign domination, aggression, and serious human rights violations. So these definitions apply in those particular regions in addition to the 1951 Refugee Convention definition. Is anyone excluded from refugee protection? Well, under Article 1F of the Refugee Convention, there are grounds for excluding people who've committed very serious crimes from refugee status. These are crimes like war crimes, genocide, crimes against humanity, serious non-political crimes committed outside the country prior to seeking asylum, or acts that are contrary to the purposes and principles of the UN. So something like terrorism would definitely be encompassed within that framework.